the no, that's not specially. It's the Special Planning Commission for February 28, 2019 to order. If you would, please rise for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Right. Who's on point for this one? Do we have any changes to the agenda? No changes.
Good morning. There are no changes to the agenda.
All right, and before we get into that, Lisa, we need to see if there are any citizen comments. So is there anybody in the audience who wishes to come forward? Anybody at all? Anyone?
Do we have an audience?
Seeing no one come forward, we're going to close the citizen comment portion of the hearing and move on to the published agenda. And Ms. Barrett, as we work through this, I'd like to go line by line so we can make sure we cover everything. So if we could.
Line by line of your agenda?
No, of the edits, the suggested edits.
Okay.
So if you would, keep that in mind as you move through it.
Okay, well.
Please say it's a joke.
Okay. Okay, thank you.
A little early, I guess.
Yeah. She has a planner. She has no sense of humor.
It's on record.
Unlike engineers.
Yeah.
Yeah, the party guys.
Oh, sorry. Go ahead.
Should we say something about architects or just?
Okay, I'm just going to read the title into the record, and then I'll turn it over to Pat Tayeski, our consultant, who has been working with us on this project. It's LDCT 1705, Ordinance 1903, formerly known as 1803, Land Development Code Text Amendments, county initiated, and we also refer to these as process improvements, and this is a legislative matter. Like I just said, we've been going through this for approximately 2 years. We are back before you. This item has been before you in September, but I'm going to let Pat explain why we're back before you again.
Okay, but before you do that, I was reading the kind of the history, and there's a reference that I think it said on February 5th it was remanded. What does that mean? It is coming back to you. The Planning Commission on September 13th, 2018, by a vote of 6-0, recommended approval of the amendments. When we went to the Board of County Commissioners in December, there were some questions that were raised by the board and by the public. We made some amendments, and the board and the county attorney's office felt that those amendments had to come back before you today. So that's why we're here.
Yeah, Mr. Chair, just to head off any legal challenge whatsoever on due process, we went through all the hearings. So this is the draft, same draft going to board.
Okay, very good. I didn't know if that was a formal process. I've never seen it referenced in a public hearing context.
Well, it's a legal opinion that we have.
Thank you.
Good morning.
Good morning.
I have a PowerPoint that I'm going to go through.
And for the record, this is legislative, so nobody has to be sworn, and there is no ex parte constraints.
Where is that? Is it this one?
Yep, that's
Okay. Nope. Okay. Perfect. Thank you. Okay, so we're going to talk about the reason why we're back to the Planning Commission. And because we have 2 new members, we're going to give you a very brief overview of what we've been doing. Very brief, I promise. And then we're going to talk about the specific changes that brought us back to the Planning Commission. And we're going to talk about some additional changes that came up as we went through the process and then the schedule. So why are we here? So Lisa mentioned we came to the Planning Commission in September, and you voted to recommend approval of the LDC amendments. But when we went to the board hearing on December 6th, we had a lot of conversations, and we also had some public comment that raised some questions. And the board decided that we needed to go back, look at all those questions that had come up and figure out if we needed to make some changes. So the main items that we noticed that we needed to make changes to included the mandatory connection to the sewer system, the density bonus for the UF3, future land use category, a provision that talks about meeting notices to neighborhood associations, and then the idea of administrative permit versus administrative approval. So those were the main 4 issues that ended up creating changes in the LDC. Now, other issues that were discussed at this meeting included building height and building compatibility, but we ended up not having to change anything substantial. There was a lot of talk about general site plan versus, general development plan versus preliminary site plan and final site plans. Again, minor changes, nothing substantial. And then we also got into a lot of talk about the environmental chapter, which includes wetlands. Staff was proposing some changes that it was the opinion of the board that they were substantial to be considered as part of these process improvements, and it would be better if we just consider those separately. So we're going to look at that chapter as a separate scope later on. We also got into the access and connectivity discussion. There were some changes that had been proposed by us, the consultants, and also the transportation staff, and the board felt that we needed to discuss those separately. So we decided that chapter 10, we're not going to make changes to it at this time. We're going to bring it back at a later time. And the last one, we tried to clarify something in the plan development section, but ended up causing some conflicts with some lawsuits that are going on, and we decided to just leave it the way it is for now. If we need to make changes, we'll do that at a later time. So this is the project overview, the very short version of it. So we started working on the Land Development Code back in 2015, and at that time, we did a reorganization of the code. Over the years, there had been section after section after section changed, added, moved, and the code was not very easy to follow, so we just did a complete reorganization of it. Then in 2016, we decided to attack a priority that the county had at the time, which was what's happening in the urban corridors, meaning the urban core of the county. Development is happening near the interstate, but this older side of the county was not doing well. So we worked on that. The changes to the code and to the plan were adopted. We were done with that. And then by the end of 2016, beginning of 17, we started working on the current scope, which we call it process improvements. And this is what, we thought we were done. We're going to be done in December, January, but we're still going for a little bit more. So, and something about that one too. So this scope included changes to the plan and changes to the code. The changes to the plan were already adopted back in August of last year. So now we're dealing with just the Land Development Code. So we call it process improvements because it has to do with the requirements to go through special approval, requirements to go through plan development, and then the fact that the future land use map and the zoning map don't really communicate with each other, so it makes things really difficult when it comes to development approvals. So it sounds easy, only 3 items, but when you talk about special approvals, we're now talking about over 52 types of activities that would require you to go through that. So we had to go one by one, and the main topics that we had to address included mixed use, buffers, coastal areas, clustering, development size, affordable housing, and realized that we either needed to beef up those standards, create new standards, or just realize that the standards were already in place. For plan development, this is something that we noticed that the county, the urban portion of the county, almost half of it has gone plan development. And we want to minimize the reliance on that. Plan development is here to stay. It will continue to be available, but we just didn't want to push everybody through plan development. So as we went through that process, realized that it addressed the same types of issues that special approval addressed: mixed use, coastal areas, buffers, development size, clustering, affordable housing. So that's why the process was that long. It was only 3 items to begin with, but it encompassed a lot of different topics. And then the last one I mentioned, we have a future land use map, in the county, and then we have the zoning map, and it's very difficult to work with those two at the same time. And then I mentioned, as we went through the process, got into, other topics like subdivision access, connectivity, environmental chapter, but those, we're not making changes to those at this time, unless they relate to the previous topics. So this is just to give you an idea of all the different meetings that we've had as we went through this process. Started back in December of 2016, we have had workshops, work sessions, hearings, and then you can see in the yellowish color, that first hearing with the board was December 6th. That's when we got all the public comments, went back to the drawing board, came back to the board on January 10th. They decided that we needed to go back to the drawing board, basically. We needed to start the process with the Planning Commission so that we made sure that all the ducks were in place, that we needed to follow the regular process for any amendment of the LDC, Planning Commission and Board, 2 hearings. So I mentioned that the changes requested by the board, based on the public comments, boil down to 4 items. So I'm going to go through those 4. So sewer connection. So when we talked about the mandatory sewer connection provision, we decided to refer back to the Florida statutes. So when we did that, we included the reference to that section of the statute, but then we didn't realize that we were making it more flexible than the county already had it. So one of the commissioners noticed that and said, it's okay to refer to the Florida statutes, but we don't want to open the doors to all of a sudden start allowing larger subdivisions without connecting to the sewer system. So we got rid of the provision that says, per Florida statutes, because we can be more strict than the statutes. And then for item C, noted that for any proposed residential and commercial subdivisions with more than 5 lots, period. No reference to 50 lots, because that would open the doors to pretty much approve more subdivisions than we were doing in the past. For the next one, this has to do with affordable housing. So we had talked about how the comp plan talks about we need to encourage affordable housing and we need to have a bonus system so that they can have more density. And we were trying to do all this with zoning instead of sending them through PD, because PD makes it more expensive and it's very unpredictable. So in the process, we said, okay, so let's list all the zoning districts that somebody could use in order to achieve that bonus density, and created this chart. And one of the commissioners noticed that UF3, we were showing it as a 9 dwelling unit per acre bonus, and she was saying that UF3, if anything, should be more similar to residential 3, if not less, because it's more of the suburban area. So they recommended that we scale that down to 6, so now they're consistent. Now there is one item that came up just yesterday, and the way we were doing this process was that the developer would come in and say, I have Res 3. That means I can have 6 dwelling units per acre. So what zoning am I going to get? It's like, well, if we give him RSF 3, he's not going to be able to do 6. Maybe staff can say, okay, the code does allow 6. Okay, you can do 6. But wait a minute. RSF 3 says that I have to have these large lots with large setbacks. How am I going to fit 6 units in those parameters? So just before the meeting, we were talking with staff about the fact that we could, like right now, the provision says that if you're affordable housing, you would rezone to an RSF 6H, H meaning it's affordable housing, and then later, if that project doesn't go through, or if it's destroyed, or if it goes away, right now we're saying you would have to just get rid of that zoning and go back to RSF 3. But then the CIO's office said you cannot just rezone automatically. You have to go through a hearing process. So what we were talking about with staff was that maybe we just require whoever the new owner is, or if it is the same owner but they're not going to do affordable housing, to rezone again. So, okay, we gave you RSF 6 before because you were going to do affordable housing, but you're not going to do that anymore, so now you're going to have to rezone back to something that is consistent with your land use category. So I apologize that just came up at the last minute, but we think we have it figured out with staff. Now, the next topic that we discussed with the commissioners, and it ended up not being a substantial change, but at one point we thought it was going to be a substantial change. So right now the code says that when you're going to have a hearing, you have to notify property owners within 500 feet of your property. But it also says that if there is a site within those 500 feet, and that site belongs to a homeowners association, that is, the rest of the subdivision is not within the 500 feet, that association needs to get noticed. So it was confusing, the language, and we realized that it needed to just be simple, to the point. And the commissioners considered changing the 500, but in the end voted, and it's staying at 500. So the change here is just clarification. It's no substantial change.
Is the entire
Not all the lots within that subdivision
Just
will
the
be noticed,
homeowners
just the lots within the 500 and the homeowners association. And at that point, the homeowners association, they can let everybody else know if they want to.
Thank you.
And this one, as we made changes with the reorganization, we reconsider the administrative permit requirement. And as we were going through the changes this time around, realized that what is an administrative permit? There is not such a thing. I mean, when you have a use, it's either permitted or it requires a special permit. But an administrative permit was not really a thing anymore. In the old days, before even the reorganization, we used to have a section in the code that had additional standards for certain uses. And the AP in the table of uses would mean, oh, just go to that section and make sure they meet those conditions. And they used to call it administrative permit. This time around, we realized that it's not a certificate, it's not a special paper that you're supposed to get, it's just administrative approval. So we're just deleting that whole section. It's not an extra process that anybody has to go through. It's just a regular permitting process that anybody would have to go through anyway. So for that reason, we're deleting this whole section. And before I move to the next part, any questions about any of those? Sewers?
I would like to delve into it a little bit deeper after the presentation.
Okay, we'll go back then. So as we went through all those changes, we noticed recently that we needed to make an additional change. And when we were talking with the commissioners about how we're creating a new district, the RSF 9, to allow smaller lots, when you allow smaller lots, you are supposed to allow smaller setbacks, because otherwise how are you going to fit the house on the lot? And we were proposing a 15-foot front setback for homes in the RSF 9 district. And one of the commissioners said, well, if you have a 15-foot setback, where are you going to put the car? Because the cars hardly ever go in the garage. So then we added a provision that says your garage is going to have to be placed 25 feet from the property line. Your house can go up to 15, the living area, but the garage is going to have to allow enough room for the cars to be parked outside. And that was the only change that we noticed. In terms of the schedule, so we're going to have the first public hearing with the board on March 7th, and then the second hearing will be March 21st, and then after that, then we'll be done with the LDC amendments. I'll likely go back if you have any specific questions of the changes.
Specific to the sewer.
Yes.
I read that language in the code. I was trying to find in my notes what section that referenced. I think it was 2.5, chapter 2. Trying to pull it up.
It should be chapter 8.
Well, the definition.
Oh, the definition. Okay.
I focused a lot on the definitions. That's where of course, where it's defined. So, it seemed like the proximity of the service was tied to the right-of-way. And it wasn't completely clear to me when I read that if we're talking about the 50 feet, if the service is within 50 feet of the lot adjacent, or in some instances it made reference to I think some larger distances. So let me see, I think on page 2.5 and 2.6, yes.
Yeah, this is copied word for word from the statutes. So basically, they say that if you have the lines in front of your lot, then you have to connect.
Right, and the definition, when I read it, it seems like if the right-of-way is in front of your lot, that that would be the determining factor. It seems to be tied to the location of the right-of-way, not the location of the service. I think the intent is,
Located within right-of-way.
generally speaking, but not in every case. Yeah.
It would be, located within the right-of-way and/or in an easement, because, the mandatory hookup would only be to public sewer, not private sewer.
So if you had say an 80-foot right-of-way and the utility was located outside of that on the opposite side of your property line, would they still be required to, in an easement, would they still be required to connect to the sewer?
Well, I did discuss that with the utility department, with utility engineering, and they did say that if the gravity, I think it's within 50 feet of I know it's an 80-foot right-of-way, but you can cross, nowadays you can cross fairly easily with
Right.
directional bore to tie in. And I asked the question about force main as well, because a lot of times, you require a lift station if you have that. And they also said that depending upon the size of the force main, that they would let people tap into them as well. So, I mean, it's, a lot of this is going to have to be done on a case-by-case basis.
Right.
What is it, and what is the cost and the important, but I do think that we're trying to get people to tie into the sewer that we have out there.
Right, and that's my point exactly, that the language seems to allow an out for somebody who maybe would want to argue the point that they
Because
shouldn't
it's
connect.
not on the same side of the street.
Yes.
Okay.
Yeah, I think the distances could be larger, either that or if it's adjacent to the property would be a more appropriate point of reference as opposed to within the right-of-way, 50 feet within the property.
Mr. Chair, if you don't mind.
Mr. Gerstenberger, yes, please.
First off, good morning.
morning.
Mr. Chair and fellow commissioners, Thomas Gerstenberger, Public Works Department. With respect to the changes that are being proposed with this particular section, obviously the biggest change is to remove the provision in the code that exists today for the cost estimate to be provided as a special approval process to allow for a septic system use. With respect to this particular language, the primary focus is on the distance being a quarter mile. That's pursuant to state statute, and that's with respect to the sewer infrastructure. Mr. Chair, as you had brought up, there is a significant difference in connection between a force main and a gravity sanitary sewer system. Predominantly, the connection to a sanitary sewer system is reliant upon the grade of that particular system, whether or not a physical sewer service connection can be made to a gravity sewer, whereas the connection to a force main, with that being a pressurized line, that connection can be basically irrelevant to the elevation of the infrastructure itself. I'll be happy to address any further questions.
Very good. Mr. Barnard, I saw you queuing up. Did you have a?
Well, yeah, Mr. Chair, it's in detailed discussions with Board of County Commissioners, they made it very clear that anytime there was an opportunity to have the customer connect to the sewer system, they would like to see that done. I think you're seeing environmental aspects coming to the surface, if you will, that, could be construed as having an impact, a negative impact on the environment. So, the more customers that we can connect to our sewer system, the better off this county's going to be. And we're also monitoring legislation that's being proposed that is going to make it more difficult, and more stringent rules on septic systems and things like that. So, there's a trend across the country, particularly in Florida, with red tide and other events that, what can we do to help our water system?
Very good. And I 100% agree. I think the language could be actually written, modified slightly to make it a more restrictive, where you reference the distance from the point of service, not necessarily with referencing the right-of-way.
The point of service.
Yeah. That's really what they're doing. From the property boundary to wherever they're connecting, it's irrelevant that it's within a right-of-way or an easement. It doesn't really matter, but it could be within a right-of-way some distance away, but the right-of-way is adjacent. It still gives them a path of connection. So, very good. Mr. Rutledge.
May I ask you to explain again the process? I'm sorry, I'm jumping to housing.
Yes.
Sorry, Mr. Commissioner. Good to see you, though.
Don't go anywhere, Tom.
So my question is this. Can you explain more clearly the conditions of a tax credit housing conversion back to the rezoning if they don't get approval? Because there's obviously a process when somebody submits for tax credit housing or subsidized housing. There's a process. So they go to a landowner, they say, okay, I want to put this here, but they don't acquire it until they get their approvals. And are you saying that process follows that expectation and then has to be reverted back or has to be processed? Then if they don't build capital approvals, et cetera, it has to be rezoned again. I'm not sure I follow the process.
So right now, when somebody wants to do affordable housing, they come in and they say, okay, I have residential 3. So that means I can have 6 dwelling units per acre if it is affordable housing. So they rezone to PD. And when they do the PD, they figure out the standards for that development. That is still in place. People can still do that if they want to. Now, if somebody wants to not go through PD because maybe they don't have the specific plans just yet, they can come in and say, we're going to do affordable housing, and we're in residential 3, so we want to use just the conventional zoning districts to get there. So how do I do that? So you apply for a rezoning, and you go to the Planning Commission and the board, and you say, I am requesting RSF 6, so I can do 6 dwelling units per acre. So when you all review a rezoning, you always look at, okay, is it going to be compatible? Does it fit in, whatever? So, okay, yes, we approve the RSF 6. The developer can follow the RSF 6 standards, setbacks, height, and all that, and develop the project. Now, let's say that for some reason it just never worked out. They were never able to get the financing or whatever. 5 years later, they decide to sell that property. So now a developer comes in, and they're going to do just a regular development, not affordable housing, and they go, oh, we have RSF 6. And staff is going to say, well, that RSF 6 was specifically approved for an affordable housing project. If you're not going to do an affordable housing project, you need to go back to a zoning district that is consistent with your land use category. You have to go back to RSF 3. So originally we had worded in a way that it would just revert back, but we can't just do that. Rezonings cannot happen automatically. So we're saying it would be up to the new property owner to rezone to any other district that would be consistent with your future land use classification.
And so this occurs after a zoning change has occurred and then wants to go back. It's not while it's in the process of being done and it falls apart.
No, it can stay there for 20 years, for 25 years. It's not until somebody else wants to do something completely different with the property, something that is not affordable housing. Now, if they sell the property and somebody else buys it for affordable housing, they're set. It's there. It's for anybody who wants to do affordable housing there.
But it's only after the zoning has been achieved for the affordable housing.
Yes.
And then you have to go back and say, no, I'm not doing that anymore, and all that plan is scopated, and I'm going to do this.
They just leave it there and walk away.
Understood. Thank you.
Mr. Chair, and one of the key ingredients to that entire formula is working with the folks in the affordable housing area, and we'll have a pretty good idea if things are going to work out prior to public hearings on rezoning, so that we don't go through an exercise of futility where, you know, we get somewhere where they didn't really want to be or they can't make it work. So I think we're really going, you know, there's a major investment to the developer to go through all this. And everybody up here probably understands that better than I, that you need to have some surety before you go through that process. So I think while the final approval hasn't been or won't be given at that time, we'll have a very good idea that it does meet the criteria and we don't have to go back.
And I think of then the stacking on top of that is capital and equity. And if those things fall apart after you've achieved all this, which I've seen happen, that was part of my concern. So, okay, I understand. I think it works fine. I just want to make sure I understood where the bifurcation was, so that's helpful.
You know, one of the things with capital and equity is the speed with which you process the application. And it's our hope with this new process that we will achieve that speed that the developer needs in order to maintain that capital and equity.
Yes.
Time is money.
Right. Perfect. Thank you.
Mr. Roth, did you have a question?
I'm going to ask for an example, and I don't know if it's appropriate. 20 acres, let's call it Lena Road, currently forward zoning UF3, and currently agricultural. We're going to have to rezone it. The applicant, or the fellow who wants to buy the property comes to me and he says, well, what can I do? So I call, and your planner tells me you can do 12. How do I get to 16? How long does it take me? What is the system?
For affordable housing?
Yeah.
It is an application for rezoning. So if you go the PD route, you would have to prepare plans before you even get to the board. For a rezoning, you just submit the application for rezoning. Now, in terms of how long it takes, I'm going to let Lisa or Margaret talk about that because I don't know the process in terms of timing.
I would think in the example, not tied to any specific property, just a theoretical example.
Just somewhere in there.
It started out as agricultural, so I guess the idea is it's going to have to go through a rezone regardless. So I think the question is rezone versus affordable housing rezone.
And the bottom line too is what is your future land use category? Because you may be agriculture, but if you already have residential 12.
It's right here. It says UF3, and that's what it is.
Oh, UF3.
Current forward is UF3.
So if it is UF3, you could go up to 6 dwelling units per acre for gross density. So you would request a rezoning to any of those districts that are listed in that row.
Okay.
So now, when you ask for a rezoning, let's say that you ask for the RMF 6, and if you've seen it before, when the rezonings come before you, people are not guaranteed all those zoning districts. Maybe you look at the situation and you go, 6 is not appropriate in that area. We can approve up to 4.5, for example. So it's not a guarantee that you get all these different districts. But it is a rezoning, so you have criteria that the board and the planning commission would have to go through to make sure it meets that.
The rezone as it would be before, with the stipulation of affordable housing, which is okay.
Yes, and the other difference before, because it was a PD, you would have a plan. But if that person sells it to somebody else and their plan is different, still affordable housing, they wouldn't have to come back to the board for approval.
Any other questions on the particular matter? And again, one of the things I did is I went through the definitions to try to make sure I understood and generally focusing on the things that were previously edited, either deleted or added, or but on the definition of development, which is on page 2-14, I think it might be appropriate to go back and review state statute, the definition of development. There was a section in our proposed code. I guess it's actually in the existing code. Actually, there's an error on the F. There's just a hanging R on the end, but the section that references the division of parcels or dividing land into parcels as being development. I think there's more specific language in the state statute that identifies that. So you might want to just take a look at that particular section, the section dividing land into parcels as being development.
Mr. Chair, I did want to say this was checked once already under the state statute in recent amendments. Sometimes the Florida statutes are not specific.
Right. And then, somewhat related to that, I went on to the definition for multifamily dwelling unit. And I think we've created a little bit of a conflict. That's on page 217. The definition shall mean any building or group of buildings containing 3 or more residential dwelling units, but we include a duplex, which is 2 units in that definition. So I think it either needs to say 2 or more units or strike duplex from the definition.
I think is when you're talking about a group of duplex units. So if you have just one duplex, it's a duplex. When you have 2 duplex units, that's 4 units. So that exceeds 3.
If you have 1 duplex, is that a multifamily?
I don't think that's the intent. Because it says examples include groupings of detached dwelling units, duplexes. So it is not a multifamily.
Yeah, Mr. Chairman, I mean, what we're trying to do with this definition is we're seeing some different kinds of developments come in where they're actually not attached. They're individual units on a single lot.
Are you talking about a land condo?
No, ownership is not the issue. It is the development style. A lot of these are going to, some that we have seen are going to be rental units, but they are not the typical, what we think of as multifamily. They're individual units on a single lot. So, and you could have, and then some of them have mixtures. They have, single units, not attached to anything. Some of them have duplex type. Some of them have quadplex, all within the same single development parcel.
So would for lack of a better description, like a cabana, multiple little cottages on a single lot, that doesn't seem to fall in the definition of a multifamily because they're not attached.
But there, it says examples.
They can be detached or attached. And that's because we're seeing people are coming in other parts of the country, they do this currently, where it's multifamily because it's a single lot, and our definition always was that it had to be attached to be multifamily.
So that was the intent of the detached dwelling unit, is a multiple single dwelling units.
Yeah,
correct.
3 single-family homes.
And
in a
again,
lot.
that's not clear in the way it's described. I think maybe a little bit of clarity. I understand what the example makes it very clear what the intent is.
I think you'll see as we bring forward more improvements, particularly with the accessory dwelling units, will fit the category very nicely.
Right. So, Mr. Rutledge.
And so would this be described as my she shed or mother-in-law's? I mean, would that be this?
Yes,
No,
that's
that's
accessory
not
dwelling units.
multifamily. The accessory dwelling units are not being counted as multifamily. It's a
Understand, but-
single-family develop. So you're talking about, on a single lot, we are proposing to have accessory dwelling units.
Right.
That's not considered multifamily. It's
This
still a
is-
single-family lot.
This is if you have your mother-in-law's
Right.
house
Or the
and
she
your
shed,
ex-mother-in-law. She's got her own cottage on the back too.
Oh, God. I've only made one mistake. That's not one of them.
Yeah.
And that you have, and again, it's based on density. We're not counting the single accessory dwelling unit that you can have on a single-family lot towards the density. But if you start putting 3 and 4 units on a single lot, then you need to be able to meet the density
So
requirements.
the intent is clear, but I think maybe a little wordsmithing might help, or in this case, maybe a little additional language, or maybe, well, it is a definition, so it'll be used. Yes, sir.
So, and this would be kind of like the example where somebody came in and you can't have a bathroom kitchen in an exterior building, and that was okay, but you can now? I mean,
And that's what I want to clarify. The amendments today do not include accessory dwelling units. That will be a separate ordinance coming before you in the future. You have a work session next month at 8:15. We'll be presenting the ADUs, accessory dwelling units.
Okay.
That is separate from the definition of multifamily.
Okay, thanks.
Okay, and then one other thing that I saw just in reviewing again what was previously redlined is on page 2-47. There was some additional language added. Again, a replat is defined in, I think, Chapter 177 or 17. I think it's 177. It's the platting standards. So anytime you take a plat back through the process is considered a replat. This seems like it's more restrictive than. So you might, again, this is just something I saw. You probably talked to the county surveyor, and they may have an opinion that would be different. But I just know that because I recently replatted some land, and the scenario was a little bit different described in the definition. And I think the other one that had added language actually relevant to what was recently brought up was. Mr. Gerstenberger still here? It was, let me make sure I get on the right page, number 32.7. I'm not finding it very quickly. Thomas, there was I'm sorry, it was section 3. Section 3, page 47, or I'm sorry, 32. 32, yes, ma'am. Said it went through this line by line.
You weren't joking.
No.
Good job.
Engineers, they never joke.
This is the large project.
Just reading this, and a lot of times I focus on stormwater. So on number 7, bullet point 7, or not bullet point, number 7, surface water. Post-development conditions, estimated post-development annual surface water pollutant loading rates. How do you propose that to be done? Where did that language come from?
Okay.
And the double underline means this was just moved within the code. This is not new language.
Right.
I'm not sure.
Me or you? Me? Okay.
Me?
From what I just overheard Margaret saying, it was a provision that was included in large project criteria, but it's being moved to what I understand.
Project.
Okay. So as far as large projects, those would be those over 800 units for residential. So there are additional provisions that are in place for large project criteria status as far as additional, I wouldn't say requirements, but additional information that's required at a general development plan stage for a large project. There is some additional detail as far as the stormwater and floodplain information goes, and as far as water quality treatment with respect to that particular criteria. To me, it's surmising more upon the total maximum daily loading, pollutant loading, things of that sort, than it is any of the requirements that you might see and that we talk about in a public hearing as far as the flow reduction or the water treatment quality, increased water quality requirements that we have for water protection overlays, whether they be for Evers Reservoir or Lake Manatee, things of that sort. That particular section that you're looking at, Chairman, that particular section is not necessarily something that we review in detail on the stormwater engineering end. However, it is reviewed in detail with the natural resources, environmental planning end. So that's more of that particular provision. It wouldn't necessarily fall under my auspices, but it would fall under, per se, like a Robert Brown or Greg Blanchard, Scott Browning over there in natural resources, then it would fall in stormwater engineering.
I know typically those are the requirements if there's an impaired water body demonstrating
yes.
it, but it seems it seems presumptive that there would be a need for that if you have just the fact if you have, say, for instance, agricultural land and it's you remove cows from it, you're doing an improvement on that particular element, whatever the impairment for the water body might be. So
right. And as you're alluding to, it is more on a site-specific basis as far as if there is an impairment, what that particular impairment is. And in most cases than not, just the conversion of the land will demonstrate an improvement to the water quality than per se the use itself.
Very good. Okay, thank you. Those were some of the broader topics I had marked up. I had some more detailed, but I'll spare everybody that. Also, I did notice that we talked about it before that like when we talk about density on lots, some of the higher, like RSF 6 or RSF 9, residential single family, 6 units to the acre, 9 units to the acre. I've spoken with you previously, Lisa, that the math doesn't really work when you actually try to put 9 units on an acre and you have the minimum lot size, or that criteria, or the it's mainly the lot size that causes the constraint. And I know I think every forum we've had where we've discussed this, I brought it up, so I didn't want to miss the opportunity to say it again.
That's when you do infill,
Yeah.
it would be the only time that it would work.
Yes.
So.
I know the intent, but like I said, I don't think the code quite allows it and it's simply the minimum lot size that constrains it. So, anything else? Anyone? Okay. All right. Thank you very much. All right, we're gonna go ahead and open this up for public comment to see if anybody in the audience wishes to come forward and make a statement. So, if you care to make a statement on this, please come forward and state your name. Morning.
Thank you. Good morning, Mr. Chairman. Before we begin, I have a signed statement from 5 people that asked me to speak for them today, so I guess that gives me a little extra time. Is that correct?
Sure. I mean, we don't have a lot of folks here, so so.
First of all, somebody's pen here. Does this belong here? Leave it here? Okay.
It's a lightsaber. Be careful.
For the record, I'm Ernest Sandy Marshall. I'm first vice president of the Federation of Manatee County Community Associations. I've appeared before some of you, and I see some new faces up there, so that's who I am. I've lived here since 1951, and I've seen a lot of changes in this county since then. And I'm retired now. I was a lawyer, trial lawyer for 50 years, and I handled 5 areas of law, both as a consultant as well as a lawyer. One of them was real estate. So I've had some experience with some of the things that we're doing here today. One of the things I would point out right at the beginning, I think, Mr. Chairman, you pointed out a very valuable point, and that is more clarity is better than less. That's where you get into trouble when you go to court across the street and try to sort this out. If a definition says this in a code, statute says this, and then somebody else has got another definition. So you got to reconcile all that. So the more you can do in that direction, I would urge you to consider that. Also, did you receive, the Federation directed our newsletter editor to email to you a copy of a landmark case that just was ruled out in Pinellas County. I assume some of you are aware of it, where Pinellas County got hit with a $16 or $18 million judgment because there were some mistakes made in the process of going from bringing the application in until it got to the court. And the Florida Supreme Court upheld that. I didn't know it at the time when I spoke before the county commission when Mrs. Schwenk was there, that it had become a landmark case, but it has been. It is a landmark case now in Florida on all issues concerning how you go about doing what you folks have this laborious task to try to do with no pay. I mean, your pay is great, but bottom line to it, if there's any mistakes made, they point a finger right at you. And then after they do that, then they point it at the county commission, and then they go from there and possibly file a suit. So all that needs to be avoided if we can. We got a nice county, and we want to keep it that way. That was furnished to you. Is anyone that did not receive that? Raise your hand.
I haven't seen it.
Okay. Well, it it was sent out, I think, this past week, and so bear with us on it. You should get it, but put it in your file folder and take a look at it. It's really important for you to see what they're saying about how you go about it. It's one of the best opinions I've seen written in some time. Now, to get to the point of this is an example in that case of something that is important. I know when I appeared here before you the last time, I'd asked the question if the police powers were contained within the new land development code, and Mrs. Schwank was very kind enough to send me a copy of the pages that showed that it is. And that is very important because this case I just told you about talks about those police powers. And you need to keep that in mind because police powers trump all the codes, the statutes, because it's a sovereign right that belongs to the people. And that's why you need to read that. We gave some research. I dug out of some of my old books I still have left at my office for the commission on police power issue at the last hearing we had that brought us to this hearing today. And it's very important that you take note of that in that case because basically a person can't use his land to damage the other person's land by trying to get the county or the state to approve something that causes that. That's how the police power works. That's just a simple illustration. So the bottom line to it, it also confirms that there's a serious issue of due process, and that is giving reasonable notice for an opportunity to be heard on whatever it is you're trying to do. If you cut that short by not getting notice out to the public when somebody comes in here and wants something done and asks you to approve it and then take it to the commission, if there's not been enough notice to the people that that's going to happen, that's a violation of due process. And they talk about that in this case, because in that case, the people did come in, as you've seen many times, and they will go ahead and fuss about whatever it is that they're objecting to. And a lot of times, it's not paid close enough attention to, because in that case, they point out why it's important, because it controlled the decision so that you can turn it down or the county commission can turn it down. You're not bound just because staff says it complies with the land development code. It doesn't work that way. What it works by is that principle that I just said. The police power controls these things. If staff, and I know staff works hard at what they do to kind of wade through this thing, I don't profess to know what's in all that land development code, but I do know enough about it that if you don't give proper notice, sufficient notice, so that if there's a change, for instance, if there's discretion to the staff to waive certain requirements, and that waiver takes place, but no notice is given in the notice that's published, what I would recommend, the Federation would recommend, is that you have notice of any changes or waivers from what the Land Development Code says can be done, discretion with staff. It's not that they would do it intentionally, but it's incumbent upon staff, as well as you, as well as the county commission and the public, to make sure these mistakes don't get made so somebody doesn't get sued and spend a lot of unnecessary time and aggravation going across the street. Now, I would suggest to you that the ROR category, Diane Adams is a lady that appeared at the last county commission meeting, and she spent hours looking at 600 pages of this new code. And she had enough headaches after she got done, but she's a very bright woman. And she pointed out in her neighborhood on Manatee Avenue out here where they have the ROR corridor, some of Manatee County is county, some of it's city. And she's in an area where there could be some of this ROR category being used to build on top of a building that exists there, overlooking a subdivision that's less than 100 feet from her house. They're concerned. These people that signed that note for me to be here today are part of that group, and they are concerned about the lack of notice if that happens. There are restrictions, according to what I heard at the last public hearing, that limit what can be done on ROR, so that you don't get a 5-story building suddenly shooting up within 100 feet of somebody's house, looking down into their bedroom or whatever. So, but it's something that needs to be very carefully made sure of, that it's in the code, that there will be notice that if there's going to be more than 2 stories, let's say, 2 stories, people can live with that. 3 stories, maybe not, but 4 stories and 5 and up, they can't. So tighten up on the discretion of staff on that, and if you're going to waive anything, make sure put it in the code that it's got to be included in the notice going out that says we're going to waive some of these things. And finally, I think that I've covered what I wanted to say. I don't know if I used up 10 minutes, but I hope not. My wife says trouble with lawyers, they talk too much. All right, I think that's it. If there's any questions, I'll be happy to try to entertain them for you, but I do appreciate your effort. Yes, sir. Oh, I thought you wanted to say.
Thank you very much. Thank you.
Yeah, if I understand there'll be a couple more hearings. We tried to get a copy from staff on, Mrs. Adams did, of what the changes were that were voted on so we'd understand that better. So when we have our next year, you got another hearing coming up for the commission on this, on the 4th?
Right, we have 2 more hearings.
Coming up, so it's, we've been working on this since 2013, the Federation has.
That information was furnished to Ms. Adams.
It was? Okay, great. All right, thank you
Very
very
good.
much.
Thank you very much. Is there anybody else who wishes to come forward and make a statement or a comment? Anyone at all? Okay, seeing no one come forward, we're going to close the public comment portion of the hearing and ask, are there any additional questions, comments, concerns of staff? Okay, any deliberation, discussion? Okay, seeing none, the chair will
She just wants to,
Oh, I'm sorry.
there's going to be a few things that you have to change your motions because we're going to look at some provision, certain definitions and things.
Very good.
When you're ready to make a motion, I just wanted to make some clarity on some of the changes that were discussed. I don't know.
And I want Lisa to clarify about the airport issue I brought up, or I can clarify on it.
I can try to.
Okay.
So
You want me to start?
yes, please.
Well, the airport issue, let me try to explain this. Ordinance 1904, which was just approved by the board, changed the airport overlay requirements. And now this ordinance 1903 is coming after the airport amendments. So I think Sarah's concerns is 1903 does not reflect 1904. So when it's codified, it might end up reverting it back to its original.
So the information in here is not the current information in the report?
Current being the 1904, no. But I think we can cover that, and I need to work with the county attorney's office on that. I'm putting in the whereas clauses about giving Muni Code direction on how to codify it.
Well, we need to take that text out of this book. The old text has to be taken out of this document when the board adopts it on March 21st. And I'm just saying for the record, you've already voted for consistency on the airport impact overlay district in ordinance 1904. Is that correct?
Are you
Member?
asking, and that's what I guess we have to discuss, are we putting in the language from 1904 into this?
If we can, before adoption. But I'm just saying for the record, even though the old text is in this document, we're not considering that in this vote.
Okay. Were there any significant changes or edits to that section that's shown in this particular package for the airport section of the code?
No, we are not making changes with the airport section
No,
with this amendment.
that's a statement, a question to get a statement on the record.
Okay.
And the answer is no, there were no changes? No significant?
There's no changes as part of ordinance 1903.
Mhm.
There were significant changes as part of 1904.
No, that's understood. That's understood.
Okay.
And let me ask the commissioners, did anyone have any questions regarding the airport section of this code, understanding that this is not a valid section, that the 1904, the ordinance 1904 is the appropriate section that would be in place? Any questions regarding that?
I'm good.
Let the record show that commissioners have no questions regarding the airport section, so.
Okay, thank you.
Thanks.
If I could just summarize some of the questions that were raised by the Planning Commission that we would like to address before the March 7th hearing,
Yes,
so
ma'am.
we can avoid coming back to Planning Commission again.
Yes.
Mr. Connerly, you asked us to look at the definition of available. And, we will take a look at that, about looking at the point of service not from right-of-way or the easement. We also, as Pat discussed, looking at page 5-67, section 545.E, number 3, about the affordable housing process and the rezoning.
Mr. Connerly, you brought up looking at the definition of multifamily and looking at Florida statute, so we will look at that, as well as the definition of replat. And I think that covered it.
Also, the definition of development.
Oh,
I went back and looked at my notes. The point there is that definition that is in our code is taken from Florida statute, with the exception of this portion that says dividing parcels. I think the Florida statute says 3 or more parcels. Our code does not say 3 or more. It just says dividing into parcels or something to that effect.
we will look at that.
I don't know if that was done with intent. I saw some discontinuity there. So. There's a summary of the points of question?
Yes, that's it.
Very good. Thank you. Any questions? Okay, thank you. All right. Seeing no other questions, the chair will entertain a motion. Ms. Barrett, you said there were some, or maybe it's Ms. Shank, said there were some, the motion needed to be modified. Is that correct?
I think it was Margaret Tuesday, actually, who said that.
It's more to let her clarify the.
Okay, so those were clarifications, not modifications to the stated motion or the given motion. So Chair will entertain them.
Mr. Chair,
Mr. DeLesline.
based upon staff report evidence presented, comments made at the public hearing, and finding the request to be consistent with Manatee County Comprehensive Plan in accordance with Section 341 of the Land Development Code, I move to recommend adoption of the ordinance 1903, amending the Manatee County Land Development Code as recommended by staff.
Very good. We have a motion. Is there a second?
I'll second.
Mr. Ron, second. Excuse me. Any further discussion? Seeing none, the chair will call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye. Motion passes 7-0. Thank you. Is there any additional business for the commission today? All right. Hearing none, we're going to go ahead and close the Special Planning Commission. Thank you.